Hello, this is a video about the recent case of Mazur v Charles Russell Speechlys. I'm probably a bit late to the party on this one because it's one of the most talked about cases in as long as I can remember, and it's had a lot of attention. There's been a statement here from the Solicitors Regulation Authority and a post from the president of the Law Society. And if you want to read the full judgment, you can get it on my case law database, which you can access via my blog. If you just do a Google search for W-flat case law, it'll bring up a link to the case law page, which you're looking at there. And then you can search, if you look at the tabs at the top of the database section, there's some tabs, and you can just search by name contents. If you get stuck, leave a comment on here and I'll try and answer it. So that's the case, which is worth reading in full, although it is a little bit confusing. And if you don't want to read the whole case, there's a really good video which has been prepared by Kevin Latham and Fraser Barnstaple at King's Chambers. And you can see that it's nearly an hour long. And I've watched it more than once actually preparing for this, and I found it really useful. They go through the facts, the background law, and the legislation and case law. It's really good, so I would recommend this very highly. Then let's talk about the background to this case. Now, what the case is ultimately about is whether people who aren't solicitors and can carry out work in court or preparing cases for court. So the background to this is that there's always been uncertainty about when it's appropriate for solicitors to delegate legal work to unqualified staff. It's very common for paralegals to conduct a lot of casework. There are sort of areas where this shouldn't happen and where paralegals don't have the necessary skills. But there hasn't really been any regulation of this. The Solicitors Regulation Authority was confused in this case because it initially gave a statement to the court which indicated that it was all right for unqualified staff to carry out what are called reserved activities, which is basically conducting litigation, and then put another statement in which said the opposite. So there's a lot of confusion. This has been helped by this case, but it's sort of been replaced by panic because this case says only solicitors can carry out that work. Most solicitors are aware of situations where work has been delegated inappropriately. I could tell you horror stories from my experience of unqualified staff being sent to police stations in the old days, or places where people think they've got a solicitor but they've really got an unqualified paralegal who just wears a suit and sounds like a solicitor. Then obviously solicitors are under pressure from clients and opponents to keep costs as low as possible, and therefore they're open to criticism if they do that by delegating work to more junior fee earners where they shouldn't really be letting go. In legal billing and recovering inter partes costs from other parties, there's grades of fee earners from A to D, A being the most experienced type of solicitor or legal exec with over 8 years post-qualification experience, whereas D can be trainees, paralegals and other fee earners. The thing to note here is that following this case, legal executives should no longer be included in this list until clarifications obtained, because the judge said that the legal executive who was working on this case wasn't authorised to do so. And look at grade D, and that basically says anybody can carry out work. It just says other fee earners, so you could, in theory, just go out in the street, find someone and sign them up and get them to carry out legal work, and they could be a grade D fee earner before this case, that is. So moving on, the facts of the case are that Charles Russell Speechlys issued legal proceedings against Ms. Mazur for outstanding legal fees. She defended the claim on grounds which included the assertion that Mr. Middleton, who signed the claim form at the firm of solicitors GBS, was not a qualified solicitor but a legal executive, and she made an application for directions, including an order that Mr. Middleton be replaced with a solicitor. Now, GBS did replace Mr. Middleton with a qualified solicitor, but the county court went on to hold that it had been all right for Mr. Middleton to sign the claim form, and ordered that Ms. Mazur should pay the legal costs of the application which she made for him to be replaced. Now, Ms. Mazur appealed against that to the High Court and was successful. Mr. Justice Sheldon, in the judgment which has caused all the fuss, held that the county court judge had been wrong about Mr. Middleton being able to sign the claim form, and as a result, Ms. Mazur was not liable to pay the costs of her application. I mean, the proceedings themselves weren't affected because by this time the claimants had filed an amended claim form signed by a solicitor rather than Mr. Middleton. So the only issue in the case was the liability to pay costs, but that meant making a decision about whether Mr. Middleton had been authorised or not. So the case is largely concerned with basically interpretation of provisions of the Legal Services Act. And if you want to go into the detail, like I said, the King's Chambers video is the best thing to go to. And so I won't repeat that here, but I'll just summarise it. So what the judgment here holds is that only a qualified solicitor can carry out what's called reserved activities, which basically means conducting litigation as defined in the Legal Services Act 2007. So an employee of a person or organisation which is authorised to carry out reserved activities will not be entitled to carry out reserved activities by virtue of working for them. This judgment holds that really you can only carry out reserved activities if you are a solicitor with a valid practising certificate. Now it gets worse in that under the Legal Services Act, both the employer and the employee will be guilty of a criminal offence if an unqualified employee carries out reserved activities. An unqualified person can assist a qualified person in conducting litigation, but they can't conduct the litigation themselves under the supervision of the qualified person. I mean, that's going to lead to a lot of uncertainty about what is actually assistance and what is conducting a case. I mean, in practice, we could argue all day about that, but an unqualified person could do all the preparation, which they then they could prepare a particulars of claim, and then the qualified solicitor reviews it and takes ownership of it, as it were, and then signs it, and presumably that would be okay, which is, I don't know, it's not that satisfactory. And it's, as I said, it's most unsatisfactory reading the judgment that there isn't really a definition of what is a reserved activity. I mean, for the sake of this video, I would say that it's things that, you know, signing a legal form such as a claim form, a defence, a list, directions questionnaire, those sorts of things which says you're a solicitor or asks for your role should be treated as reserved activities. Then we've got what I'm saying is the my comments on this case. And again, I think I might have to do another video because there's so much commentary on this case out there on the internet that it's worth just reviewing that. But I think everybody agrees that this decision needs to be appealed or at least reviewed by somebody who can set out clear rules. This isn't because Mr. Justice Sheldon, who made the judgment, was necessarily wrong, but so that clarification can be provided to ease the confusion arising from the case. It may be best for new legislation or regulations to be enacted to clear up the uncertainty in the Legal Services Act, rather than expect judges to act as legislators and draw up new regulations. And until clarification is provided, solicitors and their staff are going to have to worry about their claims being struck out, costs being refused, and even being prosecuted where it appears that unqualified staff have been carrying out reserved activities. So if you've got a file with a particulars of claim and a claim form which is signed by somebody who isn't a solicitor, that should start ringing alarm bells because arguably it's not valid and the firm involved are open to prosecution. as is the person who signed it and their boss. All firms involved in litigation need to review their procedures and ensure that they can demonstrate that the formal steps in conducting litigation, such as signing court documents, are only undertaken by solicitors, and that the role of unqualified staff is limited to the more mechanical support functions. I think that is where that's it, really. Sorry, the last bit I've got to say is that there's an article which I'll put a link to on here from Info Legal, called Mazur v. Charles Russell Speechlys, a turning point for litigation teams, ? Now that sets out a list of things that firms should do, which I'll just read out because it's a valuable list. And it says the immediate priorities for firms are that you should now freeze filings by unauthorised staff. So any claim forms, like I said, that need to be signed should not be signed by unqualified people, only solicitors. And the same for restricted portal access. Portal access where you're saying you're a solicitor. I think there's quite a lot of personal injury type work that's done via internet portals on web pages, so junior staff can't log in and certify on there. Then each case should definitely have a qualified solicitor appointed to be dealing with it, so you can say it's their case, rather than that they're the supervisor for a number of paralegals who carry out work, including this one. And then the firm should issue a reserved activities and roles policy, which says who can do what and make sure that all the staff know about it. Cost recording, so recording of time should be remapped and checked so that you're not recording unqualified staff carrying out work which would be defined as a reserved activity. Then all team members should be trained on the new model, and clients should be informed transparently about who is conducting their case, and so they know that there's a solicitor involved. And that is the end of that. I think, as I say, I'm going to have to do another video on this just to deal with perhaps these implications in more detail, and also to deal with some of the comments and where we're going with this one. But that's all for now.